if there, if I want to introduce Jacob, Marci, and Brett, if there has been anything that has had a greater impact on our legal system in Washington over the last decade, it has been the change in the way that children and their families are defended by their lawyers. And I think we really do have the Family Defense Department at OPD to thank for that and their continuing hard work. It is amazing to be part of that and to watch the way that they think so deeply about their cases. And for those of us who have done appeals, and especially the motions for discretionary review, we're like, wow, they are really ahead of us and are doing a lot of things that we may or may not understand. So we're grateful for them to come here. Again, this should be as question and answery as possible. Please feel interrupt the whole time and see, they're here. They've got a short presentation I think they put together, but mostly we've got this hour to just share our knowledge and gain knowledge from them. So I'm going to turn it over to the three of you.
Fantastic. Thanks for the introduction. I'm Jacob D'Annunzio. I'm the now training coordinator for the Parents Right program. And when Travis invited us, sorry, there's an echo. Can you guys hear the echoes or just me? When Travis invited us, I was really clear other experts who needed to be invited. And Marci Comeau, who is here with us, runs the Appellate strike team, or not runs, hosts the Appellate strike team. So I'm going to turn it over to her, and we've invited a couple of folks from the strike team, Jody and Connor, and I think those are the only other two. Is that right? No, there's.
Hi.
And Chris are here too.
Yeah. Hi, I'm Marci Comeau. I'm one of the managing attorneys with the Parents Rep program. I'm on the appellate strike team. I do not host it. I don't manage it. I just get to be a guest. But I'm here today with other members of the appellate strike team, and there are 4 of them today. So I'd love it if they could all introduce themselves. I'll start with Jody.
I'd like to go first, Marci. Thank you. I'm Jody Backlund. I'm an appeal attorney. My question is, why should we care about appealing shelter cares? They get moot so fast. I'm going to make you answer that, and then I'll answer it too, sometime during the presentation.
I'll go to Connor.
My name's Connor O'Neill. I'm a trial attorney in Snohomish County.
Chris?
I'm Chris Petroni, an appellate attorney at the Washington Appellate Project.
And Stephanie?
Hi, I'm Stephanie Taplin, and I'm also an appellate attorney.
All right, Jacob, on a roll.
Well, yeah, it sounds like Jody threw down the first question, but I have one question before that. How many of the folks here have done a dependency termination appeal, whether it's an appeal of right or an MDR? Okay. All right, there's some more. There's 2 pages of us now. Okay, great. Fantastic. And if you want to either come off mute or put in the chat what you're hoping to get out of the conversation today, that would be great. We could definitely make sure that we meet your needs. So if you've got specific questions and you want to ask them, that would be great. If you want to put them in the chat, that would also be great. And so, Jody, it's fantastic that your question is exactly my first question, which is, why are appeals for seemingly moot issues like shelter care so important in dependency and termination cases? So I'm going to just turn it over to the group if you have thoughts or questions or answers, and then to the strike team, which I love the name of that, by the way. Makes me happy.
Well, why not? These are super important. They change the course of the dependency. They're arguably, you can get some of the most important results at this level. If not for your client, it's systemically, but also I've worked with trial attorneys who have come back and said it changed the entire dynamic in the courtroom. That judge then responded to them and was willing to listen to them. And even in other cases, they've come back and said, they're giving me more time now. They're not trying to take away due process. So do not see this as a single case that there's nothing you can do. We've educated the commissioners in the courts of appeals. They take these seriously, and they really we see changes in sometimes the forms that they're using, the process that's going on. So these are really important, and I'll just let everyone else go from there.
Jody here. Because we can win, and that's not very common in appeals, as we know. We've had our last 5 family defense cases have been shelter cares. We've won all 5. Feels so stinking good. There's lots of other reasons too, but one appeal that we had started a long, gross process to get a super racist and super unfair commissioner fired. We educate everybody, and we also let them know that they're going to have to go through us. They want to do things without discovery. They want to do things in an unfair way. They don't just have to go through the trial attorney. They also have to go through us. And a lot of times they don't have the nerve to do it. Go team.
I'd also add that even when a specific case is moot, we often are able to get review of important issues that affect other cases. And some of the big recent wins we've had in dependency cases in WAP have been of that type. My colleague Beverly convinced the Supreme Court that trial courts actually do have to have shelter care review hearings every 30 days. They can't just say, well, let's hold a hearing if something changes, but otherwise we're not going to hold any. Nope, every 30 days. We got the notice of, I've already forgotten what it's called, notice of specific direction requirement that Division 1 made up, knocked down. So that's another big reason. And here's a bugbear that I have, so take or leave, maybe I'm just nuts, but I think we can argue that a shelter care finding, maybe not other shelter care issues, but the finding that shelter care is necessary is never moot, because it's something that can be raised in future dependency cases or later in this dependency finding at the termination stage. We should never be treated as moot because of its collateral consequences.
Go ahead, Stephanie.
I would just add in addition to those good points about educating the courts and having outcomes in other cases, it's a chance to educate the other side. I've seen a lot of cases where the state has changed its position and the supervising attorneys or the appellate attorneys have educated the line attorneys and the line social workers about, for example, what active efforts are. And that's been really useful.
Yeah, I would say that I get concessions quite a bit on these issues. And so you don't see a lot of case law coming out. And Division 2, where I do a lot of argument, the commissioners themselves will send something back. So you don't have the case law per se. So we're actually having a lot more success than we think on these. So I'd encourage people who are just getting started on these to reach out to Jody and this team that's been doing so much, because there are these incredible successes. Don't be overwhelmed by these.
Jennifer, are they doing that on purpose or is it just efficient?
Yeah, I would what Jody's saying, absolutely. It depends case by case. I've had some where they've tried to actually change things up, moot out a case that they did something pretty horrible, and Commissioner Burst let me come in and do the argument, and basically shame them for 10 minutes and didn't interrupt me. So, there are ways to find a win out of there, and they had to hear it.
How about from trial attorneys? What benefit is it to your case, even if it's moot, to do, and I think, Connor, you might be the only one, to do an appeal, an MDR on a potentially moot issue?
I'm sorry, I cut out there for just a second. Could you repeat the question?
Yeah, so we're hearing from appellate attorneys about why, following through with an MDR on a seemingly moot issue is important. What's that like for you and your client when that happens?
I think it can be rather hard for the clients to have the drive to push those forward, but I think that the issue also is for the attorneys to realize that they still need to go and pursue that for the next case that's coming up when they feel like, hey, I've at least made the progress that I need, or it's no longer an issue I can do to resolve this case. But it is that forward thinking that the attorneys need to be pushing for, that it is probably going to come up again and it needs to be addressed on this case because I've got good facts, or hopefully the most favorable facts for that type of discretionary review. But I do think it does fall to the wayside when that issue becomes moot. So communicating to the attorneys that are on the front line the trial attorneys about the importance of those issues, to push forward, that is something that we're trying to make sure through the strike team that the trial attorneys recognize and make that impact for those future families that we're helping serve.
I have a follow-up question for the rest of the group that's here.
I want to say one thing for some trial attorneys and their clients. I mean, I don't think it's gone unstated that the shelter care hearing. I think Jacob and I we train on this. We train that it is the most important hearing in the case. I mean, obviously, termination of parental rights is very important too, but in terms of driving the direction of the case, it's the most important hearing. So when things go, if they don't go well, or if the court orders out of home placement and we want to drive the direction of the case differently, for some clients, appealing or seeking an MDR on that hearing, really it is very important to the client, even if it's going to be moot. So like for the client in BBB, for example, the one who had 4 or 5 30 days that were all status quo, that was important to that client. Even though those hearings were just repeatedly going to be status quo orders over and over, that client, because in that case, the shelter care and the status of shelter care was very, very important to that client. And that ended up changing the direction and the focus of shelter care for all clients across the state, but also for that client. So I think that there are some clients where it can be difficult, to see kind of the forward progress of the case, but for some clients, it can be extremely important to file that MDR, even if it's going to be moot.
So Brett put a question in the chat, which is there a difference when talking about, so at shelter care, courts have to answer many different questions. The primary question is the child going to be placed into shelter care or into foster care, relative placement? So outside of the parents' care, and visitation or family time is another one of those questions. So Brett's question is there a difference when talking about placement and visitation decisions?
A difference from what? What are we contrasting?
A difference so I guess if you have an MDR that is about placement, so placing the child outside of the parent's care, and or an MDR on the court's ruling on visitation.
Oh,
so
I see. Thank you. I say no.
There are so many different MDRs. We talk about shelter care, visitation, but I've had some where it's just the process of getting a hearing, or, ridiculous stuff from the side of what the trial court is doing. And you never know what your MDR is going to be about. But if there's something that needs another set of eyes, if there's a potential abuse of discretion, if there is certainly a violation of a court rule that oftentimes is going on and on and on. It's interesting. I find trial attorneys just tell me things that are just below my mind sometimes, that this is going on. And they're like, this is happening all the time. We don't see it in the record. That's what MDRs catch. And it's really important that if that's going on in the county or a specific courthouse, talk with your trial attorney, really get and understanding. And you might even need, I've actually used a declaration from a trial counsel to explain what's going on and attach that to my MDR. So that's an important relationship when you have these MDRs, is working with your trial counsel. But they shouldn't be worried about bringing different, challenging different parts of rulings.
So that kind of leads me to the next question, which is, and this is really for everyone, what's different about dependency and termination cases than the normal, criminal appeal that you generally see? So I would say the first difference that really stands out to me is that in a criminal case, you're really mostly dealing with one set of facts. And in these cases, they keep going, right? So facts are being generated even post the MDR filing, which is one of the reasons that I think it's so important that you stay in communication with the trial level attorney and the client. There are also, go ahead, Jody, jump in.
One thing that's different is just the level of emotion, and the client's willingness and expectation that we spend a lot more time and energy talking to them, which I think is awesome for us. But it's totally different than a criminal case where honestly, they're just kind of pounded into submission and in prison by the time we get them. So there's a lot of emotion, and there's a lot of expectations that they have to do a lot of stuff for us and that they have to be a lot of places for us. And it's hard to understand, like, there's two trains now and they don't really relate to each other anymore necessarily. And those things with the client are often challenging.
Jody, you want to talk about, and Chris or Stephanie or Jennifer, do you want to talk about how you manage that?
I have so much love in my heart. I will talk to anyone until they're done. I want to be there for them. That is all there is to it. I'm sure it's the same for everybody else, but I'll let people comment.
I think when I represent a child, a lot of times that's a very interesting relationship. And if I'm on an MDR and the child has developed a working relationship with their trial counsel, I generally defer to trial. I try to really defer to that relationship. And if the child, I will send a letter out to the child. And if the child generally does not want to reach out to another attorney, another adult in this, so I keep a very close correspondence with trial counsel in those situations. For parents, again, we some really want to talk, some just are very connected to their trial counsel. So I do take the pulse on that. If they want to talk about it, sometimes they want to talk about their trial stuff. I try to really emphasize that what my role is and what trial counsel's role is, and try to help them navigate that. I think that's a lot of it.
So another call in on the call. But one of the differences is the existence of the rules of evidence. Somebody want to talk about that? Nobody wants to talk
I
about
think
them.
it's fair that like well, especially on MDRs, right, where the world of what can be considered by the court is enormous, right? And even in dependency trials and termination trials where the rules of evidence are supposed to be applied, it seems like they're always applied kind of loosely. But there's been some really good case law that came out recently that kind of slimmed that down a little bit. And that's another example of, really good work on your guys' part to really, make it so that the rules of evidence should be applied in the right places. But this is an example of, how, this work is, it can be difficult in certain places where we have like this just enormous amount of evidence that the court considers, and how do we make sure that the court is considering it properly. But yeah, you're right. The court gets to consider everything and anything, and how do we how do we make sure it's, I guess, considered in the right way?
I think we have to rely on due process more than in other aspects. And I find myself math using everything. But that's the way we do that. And we have some statutory rights, discovery rights now that are in the statutes. Thank you all to have worked so hard on getting some meat in there. So our tools are different than, criminal cases. They're different than even termination and dependencies, but we have those tools there. I have been told by AAGs that they dislike getting those constitutional issues. They don't like having to work that hard. So bring them about. And they educate. They may not be winners, but they certainly educate. And we win in small ways. And we educate. I know that some of those AAGs are going back and talking to those, the appellate ones are going back to the trial AAGs and saying, we have to watch this. We need to change this. And I see it changed in another case. So, we may not have those rules of evidence, but we have other tools that we have to lean into.
So one of the things that we've been really trying to push for trial attorneys for them to raise particularly at shelter cares is raising issues, as Jennifer said, around discovery and around insufficient notice of the shelter care hearing. And that's because that ranges from county to county. There are some counties where attorneys get notice of the petition and notice of, and then discovery, decently in advance of the shelter care hearing. And there are some that get the petition and maybe some discovery, maybe not, an hour or two before the shelter care hearing. And so we're asking attorneys to really make sure that if they're not getting timely notice, timely discovery, to raise it, to indicate they won't be effective, and to ask for relief. And to ask that relief not be a continuance of out-of-home placement, but to ask for different kinds of remedies. So that's one of our strike team issues. But that's also something we're hoping that if there's a good record, that's something that you can be raising on an MDR. Again, that's a statutory right. So hopefully, that can be something, an issue that can be raised that's outside of, again, the enormous evidentiary kind of gamut that that doesn't allow us to necessarily raise specific evidentiary errors or anything like that because of the fact that the rules of evidence don't apply, but other issues that might be able to be discreetly raised on an MDR.
Thanks, Marci. Brett put in
Do you think anybody has the answer to Brett's question that the rent is too high? We just got too much to do, and how in the world do we put aside everything else to do the work that we need to do on the MDRs? Jody, Jennifer, you got a good answer for us?
Yeah, one idea that I've had, I don't know if anyone's thought about this, but I feel like maybe if we reduce the number of cases that people had to have, there would be a bit more flexibility in the schedule because these are pretty short deadlines, not just the short deadline, but getting a clerk to give us a file this fast is almost impossible. So if we had less pressure on all of our other matters, I wonder if we could do better.
Yeah, really?
Just a thought, you know what? I could be wrong.
Yeah.
Yeah, everybody go comment on the new appellate defense caseload standards. So the comments are open until April 30th.
And meanwhile, keep time and track your time. And when Moss Adams contacts you on the study, participate in that as well. We're going to have really good, solid information coming out probably at the end of the summer from Moss Adams that will inform on caseload. But Jody, the other thing to remember too is that even with all of that and the work on the standards and everything else, the ethical obligations exist, and Larry has been very open that he expects us to be ethical and competent attorneys, and that you need to tell him or Katrine if you can't do this within the confines of your work, and the tap will be turned off to the extent that it can be.
Yeah, they can be tricky and they're outside the flow. You get a flow of your appellate work and when your replies are and you have an accelerated on terminations, and this is hyper accelerated. It's tricky. But don't be afraid to ask for a motion to extend. The courts kind of understand that we are not your typical, the civil rules, your civil cases. We're just being dropped in the middle of this, and we're trying to get a record, and we're scrambling. So they've been fairly understanding about that, and especially like a reply having to turn around so quickly. Sometimes you need that extra time, and if they've set out, if they've set an oral argument and there's time in there, ask for that and do what you need to. But yes, on the other accelerated cases, because I do primarily dependency and terminations, I have to sometimes say, I need extra time on those because I have these MDRs. And it's like with we're all very good at juggling these things, but they do disrupt the flow. But yet, again, I just encourage you to take these on. And I find them particularly interesting and fun, and a great little nugget that you can really sink your teeth into rather than a huge record. So they're a little different, but I encourage you to try these out, even if they disrupt the flow a bit.
I love that. Thank you. I mean, these are all near and dear to my heart, and they really, in my view, really have the opportunity to do everything that folks said, changing the direction of the case, specifically changing the education that judge has, how the AGs are operating within the case. They have such a massive opportunity to shift how things are being done. And because they're all in front of a judge, it's, they're all bench hearings, bench trials. It's the judge or the commissioner that's making all the decisions. If you change their thinking, you change everything. Which, we want to change it all, because at the end of the day, seemingly all the department has to say is, but there's this child, and the court goes, oh, let's just throw out all the rules and do what we think is safe for this kid, when that's not exactly what the law says. What advice do you guys have for folks who are here with lots of experience? And I know that folks who are not on the strike team also have a lot of experience, but what advice do you have for appellate attorneys who are just starting out doing these MDRs? Jody's got lots of advice. Go.
Talk to Jody is my advice.
There's tons of people who are ready, willing, and able to help you, even though we're all overwhelmed by our caseloads, which are too high. I mean, obviously me, I like to talk. I like to be a know-it-all. So I do get appeal attorney calls. Talking to the trial attorney, they'd love to explain to you the background of their case. They often tell me they don't get enough interaction with us. So, I mean, Chris has never rejected a request for help. Stephanie's never rejected a request for help. I bet Jennifer would help you. I think Jacob would drop everything to help you. I think Marci would. I'm sure there's a ton of other people, because it's new and weird, and most of us come from a criminal defense background, at least me. So it's just a different thing, and we don't have to all be super siloed and unaware of what we should be doing. Pep talk complete.
Well, and Jody, can I just reaffirm Marci and Jacob's special awesomeness, that they really are systemic lawyers looking to make change happen, and they are available to assist you and think differently. So one of the things that we have to be doing on these, right, is like change everything. Stop the state from taking children away from families, and because they've been so good at that, we have to change the way that we think about it. And I really just, again, Marci and Jacob are, and the whole team, they're waiting for these questions, and they have strategies. They've been sharing these strategies for over a decade with the trial lawyers. And so when you get that complaint or that the notice of appeal, which should be one of the first things that you do is you get in contact with somebody at OPD and say, now what do I do? And I think that that can really help with your direction on these things. And their caseloads, Jody, are not too high.
Hi. And we love this stuff. Like when you call and, hey, I have this issue, we're like, hey. Laura has a great question. Sometimes I find the issues that the trial attorney wants to raise are not developed enough or well enough in the record to raise them. What do the appellate attorneys recommend to do in that situation? Jody.
So I just want to, I'll speak up real quick. I have a situation where trial attorney wanted to raise an ICWA issue with a shelter care hearing, and I read the whole record. Everything that was designated, there's nothing about ICWA. No, hardly anybody says a thing about it. So I'm kind of, ICWA was decided to apply later, but that was after my shelter care hearing. And so I'm just, trial attorney saying, oh, ICWA should have applied. And I'm like, but nobody said a thing. So that's just an example of, yeah, kind of stuff I'm not sure what to do with.
Was there questioning of was there the question about ICWA? Was it asked?
No, nope,
Yeah, so I
nothing.
think they can actually raise ICWA. Ding, ding, ding. There's some good case law that requires, and some statutory statute and case law requires that ICWA be raised at every hearing. It's the court's responsibility, not the parties. So I think that, I mean, the record, it'd be a great conversation to have both with the trial attorney and one of us at OPD, but it's possible that you have enough there.
Okay. And that was
the court's own failure to do what it is required to do.
Okay, thanks. That is something someone else told me too. So I'll try that. Thank you.
The other thing I would recommend, and it's not specific to ICWA, but it often impacts ICWA cases, is I would look really closely at whether you have the complete record, because I've seen sometimes where trial attorneys will order transcript of just the contested shelter care dates, and they don't order the transcript from the initial shelter care date. Or if we know it's an ICWA case, they don't order the transcript from the VPA that should have been on the record, or maybe hopefully was on the record. I've found it's more beneficial to take the time to go back and get those transcripts, even if it delays your case and your case ends up being moot, because then we have a lot of those arguments preserved later on. And I've seen that happen, like where we wanted to contest timely shelter care and they didn't order the initial shelter care date to be transcribed, but then when I went and got it, things were absolutely not done right, and we had some strong arguments. We ended up winning that appeal.
Love it. Colin's recommendation is to get in touch with the trial level attorney as soon as you can. I would also recommend that too. I think, again, because the case continues, it may be that that first issue that they sent up on an MDR has continued, has gotten worse. There's more facts to support it. And getting that to you would be generally helpful as well. But getting in touch with them is definitely.
Occasionally you have to do a couple MDRs and then link them together, and it can get complex. And so that's when you should talk to someone if you think that's coming in, and that's strategizing with trial counsel. Maybe you're going to withdraw the first and it's really the second one that they need to. So you have another set of eyes here. It's really important, if that's happening, that you take a quick look at your file, though, because you don't want to get out of the period for an notice for discretionary review. So I would say, quickly look at your record, quick overview, assess, see what you need. And also at the same time as you're opening up that record, get that first email out to trial counsel, because they may be in trial or whatever, but you're trying really hard to connect with them very quickly, so that you can get your field set up in this MDR, and then you can delve deeper into it. And but that's when you're moving quickly, those I think that would be my advice for the first steps.
Okay,
If you're
that helps a lot. Someone did say something about consolidating MDRs. I didn't even think about withdrawing the first one, but anyway, those are great tips.
I appreciate the question, Laura. The other issues are sometimes if you want to have them reconsider and add things to the record, sometimes you still have time to do that if you're really quick on getting in touch with the trial attorney. And like I said, most trial attorneys report to me. I'm not any kind of reporter, but they want more contact with appeal attorneys. They want to see your briefs. They want to hear how it's going. They want to tell you stuff. And explain why they think the issue is important. And even if it's obvious to us why the issue is important, they definitely want to talk about it. The other thing is I want to volunteer the people that I pointed out earlier for appeal attorneys. If you feel like you have a case that you don't have any issues, talk to one of us. We've all done so many that I feel confident that the trial court in a no notice shelter care situation made a mistake. Pretty sure. I think we're all raising our hands to help in that way.
So Stephanie, you mentioned doing or getting multiple MDRs from the same attorney, maybe in different cases. What about other attorneys in the county? Like if there's a court rule that's not being followed, and it's not just in that one case, and oftentimes it'll get kicked back by the Court of Appeals to say, yeah, it's a one-time thing. We're not going to worry about it. But you can always utilize us to check in to see, is this happening other places? And we might be able to drum that up for you. Not all of the trial level attorneys are filing MDRs. And if they understand that it's a strategic move to try to get a move from their court, they might be willing to do that. Other advice? Okay. So here's a question for folks who have brought OPD folks into their cases and folks from OPD who have helped. What are ways in which the Parents Rep program or OPD in general can be helpful to appellate attorneys?
Stephanie, I want you to talk about your case where you figured out what all the counties are doing in terms of appointing attorneys. I can hardly stand how great this was.
Yeah, okay. Was it Cowlitz? I'm pretty sure it's Cowlitz County had this procedure where they were systematically delaying shelter cares, the initial shelter care hearing that's supposed to happen within 72 business hours. They were systematically delaying that hearing because they weren't appointing counsel until parents showed up. So they'd show up at the hearing, not have any attorney, and then they could either go forward pro se or they'd have to wait an additional several days to have a shelter care hearing with an attorney. And so I emailed Jacob and I emailed all the parents rep OPD people, and they put me in touch with trial level attorneys in each county. And I came up with a county by county list for every county in the state, summarizing their shelter care procedures and whether people had counsel available at the initial 72-hour shelter care hearing. And it ended up not using that for the Court of Appeals because it turned out that most counties were actually doing pretty well at that. But it was persuasive value. I got the AG to roll over on that issue, agree that that was wrong. They should not have done it. They violated parents' right to counsel. And we got a favorable decision on that we could send to Cowlitz County. And now they don't do that anymore. So that's sweet.
See?
Love it.
Yeah. Big list. I came up with a map. It was great.
So other things that we're available for, if you are preparing for an oral argument and you want to moot your case, we are available and can ask all kinds of crazy questions that we've heard the Court of Appeals and the Supreme Court ask. My favorite is, if you win, does that mean the child just goes home? No, not generally. We can help with the context of what you're dealing with, right? So just the same thing that Laura asked, like, I don't understand why nobody raised this. How can this be an issue? We can help you with the protocols. Like, it was supposed to be raised by the court and by the AG's office, not by trial counsel for the parent. That's not a requirement for us. Or why is this trial attorney making such a big deal about this? I don't quite understand. We can definitely help you with that. We can help you get into touch with people across the state. We can certainly talk to you about the things that we are ranting and raving about in the moment. I guarantee you there are a lot of them. In the past, we've helped get appellate attorneys connected with appropriate amici and experts who have come on and written briefs for the Supreme Court to understand. I think the most recent one, has been a while, but the most recent one we did, we had 2 different experts come in and write information to the Supreme Court about how you are able to mend a broken relationship between a parent and a kid, right? So if the kid's saying, I don't want to go home, and everyone's saying, oh, the relationship is broken, how do you reunify families like that? Successful in one case and not in the other, which is now why we have competing cases, but they're at least helpful in some ways. Other ways that folks have been helped by OPD.
I mean, I think that one of the things because we kind of have an overall perspective of how the case law has been, we can talk to you about trends in different divisions, the difference between Division 1 on certain cases and Division 3 on certain cases, and even the Supreme Court on some of these cases. And so we can definitely have discussions about that and what arguments might be most persuasive in front of whatever division you're going to be arguing in front of. We could talk to you about, sort of obviously case law that we can be helpful for. Absolutely, issue spotting and staffing ideas. We want to make this easier for you, and we know that you guys are have too many cases and are very busy. So please contact us, and we can help you make this a little bit easier for you.
I have a question. Are you guys tracking the commissioner's decisions and the different, it would be very hard. I'm just wondering if you guys have made any effort on that or any headway on that.
I don't think that we're formally tracking the commissioner's decision. I don't believe we are, Jacob. I don't know if you know any different. We love it when you guys send us those. It's really helpful for us, so we can, again, it just kind of gives us an idea of the trends in the different divisions. It's also helpful, so we can get an idea of if you're getting commissioners' decisions out of different divisions. We also know what kind of, as you talk, I don't remember who talked, I think maybe been you, Jennifer, talks about the different advice and guidance that AG's offices are giving to their AGs and to the department. If they're getting those decisions, we know what kind of information is going back there. So if you have those decisions and you're getting them and you're willing to pass them on, we would love that. Please do. Pop my email into the chat. Please pass them on. We'd love that.
Jody, is your hand up?
Yeah, it totally is. One thing that I've used OPD for that's been super helpful is we've been trying to raise systemic challenges, especially with respect to how people of color are treated. And sometimes we do a bunch of research and we come to a study, but the study is behind a paywall. But it turns out staff at OPD can get behind that paywall. And so we've gotten good help with being able to cite to the actual studies and sources directly and reading them, of course, and being able to explain to the court why it's not right what happened here, but also put this in the bigger context. It's actual crap, which is a legal term. So that's been super helpful to get those sources. and not have to join every magazine in the world, every whatever source.
Jody, also a reminder that if OPD somehow can't get behind the paywall, Rob Mead at the Supreme Court Library can always get behind the paywall. He's going to come speak to us in a couple of months. But he can always get behind the paywall. So there's no reason if you can't get something that you can't
Thank
get
you.
it.
One other thing that I'll offer is that we're really good cheerleaders. If you rest, if you are like whatever you're dealing with, all of us will be there. We're a great ear, and we will pump you up and send you back out and tell you how much we appreciate the work that you're doing and how it's actually changing how parents are being treated in courts. It really makes a huge difference.
Yeah, we do want you to know that. Like, you know, when I started, like the law in child welfare was extremely leaned anti-parent, and it has changed substantially in the time that I've practiced and in the time that I've come here, and that's because of attorneys like you. So, I mean, it really makes a difference. Really makes a difference to be able to go into trials and, you know, cite cases that say, hey, you have to apply the rules of evidence, and you know, cite cases that say, hey, my client's entitled to have the review hearing that is, you know, set forth in the statute. Like that means a lot. So yeah.
I think one of the big things that OPD has given us is an educated trial counsel group that's making these records, and you know the work that you've done for CLEs and newsletters and all of that, and it really is helpful for appellate attorneys to see the weekly newsletter and to go to some of these CLEs that are ostensibly for trial attorneys, but we learn so much from that. So if you have the opportunity, you know, connect with OPD on that and start trying to immerse yourself in the trial attorney world, because it helps you out on appeal.
And I think at each point that we've had a conference or a training, I think we're getting better at reaching out to folks, but maybe not perfect. So maybe Travis, we can, you know, sort of make sure that the invitations go out to the folks that are doing these cases. Because if you've not practiced in them, it's really hard to understand everything that's happening, because they're super complex and very nuanced, and they're different in every county, which is also, you know, makes it hard to quite grasp everything that's happening. But coming to the trainings would definitely be helpful too, you know, in your busy schedule in between things. Are there any other like general questions, and or does anybody kind of want to talk about what they're up to? Do you have an MDR that's interesting, issues that are coming up that you think other folks might be seeing soon? Well, we hope so. Jody, you got anything exciting?
I mean, from my point of view, the trial courts are screwing up in the regular old, not reading the statute, not following the rules way. It's ridiculous and silly, but also not super complex or worthy of note.
Gotcha. Connor, anything that you're seeing in trial that you are hoping will make it up to the court?
I don't have anything as of right now. I think we are struggling a little bit with in our courthouse with not following through with reading through even the statute or understanding what the parents' rights are at shelter care. Not even wanting to hear argument from certain parties, or forgetting even to hear from a party before ruling. So we're starting to really hammer down on that. Instead of waiving the reading of the rights on the record, we've been making the judge read it out each time, which does take a little bit of time, but I think it's worth it so that we can kind of quote back to those rights when we're going into our argument issues. So nothing that I think will make it up to the appeals as of right now that I can think of off the top of my head, but we are hammering on the judges to help make sure that they understand the law a little bit better. And those things will probably start coming up to the appeals attorneys pretty soon.
one of the things I think, Connor, you're pointing to is that the judicial officers that hear these cases across the state often change pretty quickly. There's a rotation. So as soon as a judge gets on, they start with the department can do no wrong. They're just here to protect children. I'm going to side with them every time. And then about 6 months in, they're like, what the hell is happening? And then they'll start listening more to parent attorneys, kids attorneys, and more about, what the department is or isn't doing that they're supposed to be doing or not supposed to be doing. And then they get to the place where they're like, they have that, like, I'm leaving soon itis, and they stop listening again. And then you get a brand new judge and you have to start educating them all over again. There's definitely some movements to try to make sure that judges who are coming in, who are hearing these cases, are required to be trained. It's not a required training at this point. It's offered, but not required. So you can have a judge who's never touched these cases before in their lives walk through the front door and exactly, Connor, what you're saying is they have no idea what the parents' rights are and they're just going with their gut.
I think it's so important to lean into the shift that's happened over the last 10, 15 years. So an example, Commissioner Treble, one of my first cases in front of him, this blew me away afterwards. He said, I haven't done a lot of these cases, Ms. Dobson. Can you educate me about this area? 10 years before, it would have been them totally asking the AAG on that. So we've come a long way. And so these MDRs are really useful to get those new judges that are on in line quickly. And it's going to be your fastest way to do it. But really step forward, and we are experts in this area now. And we need to own that. And I think MDRs are a great place for that to happen.
Jacob, this is a good time for us to finish so that people can get on to their 1 o'clock days. A couple of things. Cassidy has just put the submit CLE credit, so go ahead and link on that, and then we will take care of your credits for you. If for some reason we don't, all of these programs that we have, they're numbered. You can always do a search and self-report as well. But Cassidy, thanks for doing that for us. Another thing that Laura and I have been chatting offline about, and then I think online, is that unlike the regular briefs that get filed in our cases where they make it to a Court of Appeals, all of those briefs are on Westlaw. That's not the case with our MDRs because they don't get published in any sort of way. So Lucy, Debbie, it may make some sense for us to collect those and create a repository for those, even though we're not creating them for the other ones, because I think it's going to be impossible for us to track all the opinions, but it isn't impossible for us for you all to just send them to us and for us to put them on our website somewhere. So I think that's a really great idea, and we should try to start that. Please, all of the awesomeness that you're doing, share that with everyone else. It's really the Strike Force team. Big thumbs up to all of you. Those of you who are also working so hard on these cases, big thumbs up to everyone. And really so grateful for the shared knowledge of everyone, including those of you who have put your whole career into teaching and training us how to be better on family defense cases. So I really appreciate that. One of the Debbie says that there's going to be some challenge for us posting these, so we're going to have to think of a way to do that or share that in a way that's going to work for privacy concerns as well. Just to let you know, next month I've had a number of requests for different content. Next month we are going to do issue spotting. And we're going to do issue spotting in perpetuity, in echoing. Michael Steinfeld, who is the Chief Appellate Attorney in Maricopa County, Arizona, who some of you may have seen speak at our programs in the past, will come and lead that conversation. We've got preservation library use, all of the things that Westlaw lets us do, coming up as different topics. If you have other topics that you would like to include in these lunch hours, I'd really appreciate it. I think that having some direction like today, and again, thank you everybody for doing that for us, makes these lunch hours a lot more meaningful for everyone. Anyone else have anything else to add? Marci, Jacob, I'd love for you two to send us off. Oh, and Jody too, because you're our biggest cheerleader for this program, and Jennifer and everyone else. But Marci, Jacob.
We really thank you guys for doing this work. It's our life's passion, and we understand that it can be complicated, but we appreciate all of the time and effort you put into it. And if you ever need any help or assistance, please call us. We would love to make it easier for you.
And if you're particularly proud of something, even if it didn't get up to the court because it got resolved, share it with us. We will gloat and glow all over you about it. We will be so happy. And those briefs are super helpful for our trial attorneys too, because they can pick and choose what's helpful for them too. Thank you. Go, Jody.
All right, folks. We'll see you all the last Thursday. Next Thursday or the last Thursday next month, issue spotting. Thanks, everybody. See you soon. Especially those who kept their cameras on.